Hmm. Oh, so sorry for the a bit of the technical hitch, but we are back. So I'm going to continue with what I was saying about onus of proof in criminal matters. Like I have said, the law has been a bit liberal on the defendant, in other words, an accused. Though right now we no longer call them accused, we call them defendant. The law is liberal in that the defendant facing a criminal trial enjoys this constitutional right to be presumed innocent until the contrary is proved. In other words, it is the duty of the prosecution to prove, to show that the defendant is actually guilty of the offense for which he is charged. So if the prosecution fails to do that, that means the case will be liable to be dismissed. And I also pointed out, quite unlike in civil proceedings, where the rule is that the party who will lose if no evidence is gathered by both sides of the litigants will have the onus of proof. The rule here is different. In criminal proceedings, the rule on onus or burden of proof rests squarely on who? The prosecution. Right. So the prosecution has the onerous duty task of working with the police, the security agents that investigated the matter to ensure that in the end they will be able to prove that the person in the dock actually is the person who committed the offense as charged, which means the onus of proof is on them. It does not shift. Now, like I also said, there is what I have talked about now is the ultimate, the legal or the general burden of proof. But still in criminal proceeding, we also have that evidential burden of proof. I'll give you an instance. If A is standing trial, maybe has been accused of housebreaking somewhere at a particular point in time, and then at the trial, maybe during his defense, he raises the defense of alibi, saying that he was not even anywhere near the scene, that it couldn't have been him. All right. The law requires him that if he knows that he is going to raise the defense of alibi, he must do so timelessly, in good time, at the point of his being apprehended, so that that's the only time you will tell the police, no, I was not there, I visited my sister, I traveled to Lagos. That is setting up alibi. You must set that alibi during the time of investigation or the time of arrest, so that the police will have enough opportunity to do or to investigate the alibi. So if a defendant may be merely thinking that this constitutional right of presumption of innocence is all he needs to rely on, and he just comes to court and says alibi was not there, the court will discountenance it. Why? Because he did not raise that issue of alibi in good time. Now, do we then say that he has an onus of proving that he is not guilty, or the onus of proving alibi? These are two different things here now. He does not have the onus of proving that he is not guilty. No. The only duty on him is that after the prosecution, he just comes to defend himself. But the issue of alibi is a special defense, which the law requires him to put the police on notice in good time, so that that his alibi would be what would be investigated. So if he fails to do that, then it will be counted against him. In other words, the issue of alibi can be equated with what? Evidential burden. You're telling Mr. A, you are the one who broke into so house and made away with some valuables. And Mr. A said, no, my lord, it wasn't me. I traveled to Lagos. And the case is that, please, at the time you were taking his statement, did you raise the issue of alibi? If the answer is no, the court discountenances, because it is an issue you must have been able to raise, an evidential issue. But if you have said yes, you have discharged that his burden. If the police said yes, at the point in time he was writing statement, he told us he went to Lagos, but we were not able to go to Lagos because the complainant did not bring money. The complainant did not mobilize us to go to Lagos. No court will be interested in hearing that. It simply means that he has done what? He has discharged that evidential burden upon him to prove his alibi. But where the, let's say, investigating police officer was up to his task and he got information and actually visited the place where the defendant said he was at the time of the commission of the crime, and he discovered actually that he was there. That means that he has created a big doubt. That means that the defendant has also proved that his alibi is correct. Once an alibi is correct, it discharges the defendant. We will come back to that. Talking about onus now. So we have agreed that the onus of proving the crime against a defendant rests squarely on the prosecution. Then the question now is, what is the standard? To what extent will the prosecution prove the case before the court will say, yes, you have proved your case? The requirement is that the proof must be proved beyond reasonable doubt. Proof beyond reasonable doubt. So we are going to consider the elements of this sentence. Proof is clear, establish, show by evidence, but beyond reasonable doubt. That is most of the times where some people miss it. Beyond reasonable doubt does not mean a proof beyond any shadow of doubt. No, like I have said, there can never be any perfect case. The investigating team will always make their own mistakes, so long as that mistake is not fundamental. Proof beyond reasonable doubt simply means you are going to prove, to show that with the available evidence you have, it will become evident that the defendant actually committed the offense. It will be difficult for anybody going through the evidence you have adduced to say that the defendant did not commit the offense. That's just the meaning. So we're also going to look at some of the case laws to see how our courts have treated that phrase, proof beyond reasonable doubt. First of all, I want to cite the case of State against Aliu. State against Aliu. State against Aliu is reported in 2023, 6 Nigerian Weekly Law Report, Part 1881, at page 569. Page 569. Here the Supreme Court said, in a criminal case, the prosecution must prove its case beyond reasonable doubt with the vital evidence that it can produce. They are not expected to manufacture evidence. They are only expected to produce the evidence within their disposition, the evidence that they have come across while investigating the matter. So if in the end, looking at the entirety of the evidence, and somebody can say, yes, this evidence is strong enough, pointing to the fact that the defendant has actually committed this offense. And then the Supreme Court also said in the same case, proof beyond reasonable doubt entails producing enough evidence to justify the charge. It doesn't mean extraneous evidence. It is not like sending somebody on a white ghost chase. Supreme Court is simply saying, if your evidence that you have produced would be enough to show that the defendant has committed offense, the offense charge, then we can say, yes, you have proved the case beyond reasonable doubt. I will also talk about doubt by the time I finish with some of the things I want to talk about here. Why would the prosecution be required to prove beyond reasonable doubt? Is because you may have some hardened criminals. You may have some defendants that will keep on changing their story. As a matter of fact, even in this case, the Supreme Court recognized the fact that the defendant has the right to change his case, to change his story. Let me tell you, here the Supreme Court said, under the Nigerian criminal jurisprudence, the defendant can change his story, but the prosecution witnesses cannot change their own stories. So that is the remarkable difference. The person in the dock may decide to change his story, but his witnesses are not allowed to change their stories. You know, why? Because most of the time they've already made their extrajudicial statements saying maybe he's our friend, he was with us, he was not at the scene of the crime. Maybe while he's testifying, he now starts implicating himself or to implicate other people. Then we'll go further to look at some other authorities. And they please read the facts of these cases that I'm citing. They will throw more insight into what we're talking about. Suleiman against the state. The case of Suleiman against the state. This case is also reported 2023, 6 Nigerian Weekly Law Report, Part 1880, page 201. It's still a Supreme Court decision, page 201. Here now, the Supreme Court took time to give us the meaning of that phrase, proof beyond reasonable doubt. The Supreme Court, at page 228, paragraph 8 of this very decision, provided the meaning of proof beyond reasonable doubt. Here, the Supreme Court said, proof beyond reasonable doubt simply means establishing the guilt of the accused person with compelling and conclusive evidence. Compelling and conclusive evidence. In other words, a degree of compulsion which is consistent with a high degree of probability. One of the ways in which the prosecution may establish the guilt of an accused person is through a confessional statement made by him. So the Supreme Court was also considering confessional statement made by this person here, and on appeal, the defense counsel labored to show that the prosecution did not prove his case beyond reasonable doubt. And the Supreme Court, in its decision, stated that proof beyond reasonable doubt is nothing extraordinary. It's not something that exists in another planet. It simply means the act of the prosecution proving their case with available evidence which are convincing enough to show that the defendant committed the offense. Not to talk of when the defendant himself confessed to the crime. He wrote a confessional statement that was not impeached in any manner. So that is what the Supreme Court defined as meaning proof beyond reasonable doubt. We still go ahead to look at about one or two more other cases, and I will discuss doubt. I will talk about doubt and some of the practical aspects of applicability of proof beyond reasonable doubt. In the case of Adisa against the state, good. Wale Adisa is also a Supreme Court decision. Wale Adisa against the state. Wale Adisa against the state, reported 2023, Nigerian Weekly Law Report, part 1888, page 85. Here the Supreme Court stated as follows. By the provision of Section 135 of the Evidence Act 2022, they put 2022 here. I'm sure that is a typographical error. The burden foisted on the prosecution in every criminal trial is heavy. Quite agreed. It must establish the guilt of the accused person beyond reasonable doubt. Throughout the trial process, the prosecution retains the burden of proving its case against the accused beyond reasonable doubt. And then the Supreme Court went ahead to also tell us, just like he did in the other case, to tell us the meaning of proof beyond reasonable doubt. The Supreme Court said, proof beyond reasonable doubt does not mean proof beyond all doubt or shadow of doubt. So that will take me to the next subtopic now. But proof beyond reasonable doubt does not mean proof beyond all doubt or shadow of doubt. It simply means establishing the guilt of the accused person with compelling and conclusive evidence, a degree of compulsion which is consistent with a high degree of probability, where all the essential ingredients of the offense charge have been proved or established by the prosecution, the charge is proved beyond reasonable doubt. He went ahead to say, proof beyond reasonable doubt should not be stretched beyond limits. It should not be stretched beyond limits. Proof beyond reasonable doubt means proof to moral certainty, such as satisfies the judgment and the conscience of a judge as a reasonable man, and applying his reasons to the evidence before him that the crime charge has been committed by the defendant, and so satisfies him as to leave no other reasonable conclusion possible. I take this last and then we'll talk about doubt. I take this one last. I have my reason why I want to look at this. This is the case 49. So this is the case of Onyeka against the state. Onyeka against the state is also a Supreme Court decision. Onyeka against the state is a Supreme Court decision. Here now, having known what proof beyond reasonable doubt means now, the Supreme Court is telling us here how to prove the guilt of accused person. So in this case, the Supreme Court says, Where an accused has denied the commission of a crime, the prosecution has the duty to prove the guilt of the accused person by any or all of the following ways. 1. Direct evidence of an eyewitness or eyewitnesses. 2. Confessional statements or statements made by the accused himself. 3. Circumstantial evidence. Circumstantial evidence. Now, we want to talk about, why do we talk about doubt? When we talk about proof beyond reasonable doubt, is because, like I have said, no one case is perfect. No one case is perfect. But when we are talking about doubt, so long as that doubt does not pertain to the elements to be proven, then it is outside the doubt we are talking about. There has to be doubt, no doubt. But that doubt should not be on any of the ingredients of the offense. I will also tell you other things where the doubt should not touch. If there is a doubt as to whether any element of the offense has been proved or not, then that doubt must be resolved in favor of the accused person or in favor of the defendant, and he must be discharged and acquitted. I'll give you an instance. Somebody lost his bicycle. He has accused Mr. John of having stolen his bicycle.